Citation number 582, Cross-examination of co-defendant's case. Date, 2004. Issue, are the relevant precedents holding that a statement made by a criminal co-defendant against another co-defendant may be admissible without cross-examination unconstitutional. Holding. Article 16 of the Constitution guarantees the people's right to judicial remedy. As far as a criminal defendant is concerned, such guarantee should also include his right to adequately defend himself in a legal action brought against him. A criminal defendant's right to examine a witness is a corollary of such right, which is also protected by the due process of law concept embodied under Article 8, Paragraph 1 of the Constitution, providing among other things that no person shall be tried and punished otherwise other than by a code of law in accordance with the procedure prescribed by law. In order to ensure the defendant's right to examine any witness during a trial, a witness should appear in court and sign an affidavit to tell the truth in accordance with the relevant statutory procedures, and it is not until the witness is confronted and examined by the defendant that the witness' statement may be used as the basis which decision as to the defendant's criminal culpability can be made. The situation of a criminal co-defendant exists due to efficiency concern as a result of either the merger or addition of complaints filed by public or private prosecutor, or the merger of a trial initiated by court. The respective defendant and the facts related to their respective crimes, however, still exist independently of each other. Therefore, a co-defendant is in essence a third-party witness in a case concerning another co-defendant. Thus, the merger of cases should not affect the aforesaid constitutional rights of such other co-defendant. It has been held in Supreme Court Criminal Precedent 31-2423, 1990. Supreme Court Criminal Precedent 31-2423 of 1942, and the Supreme Court Criminal Precedent 46-419 of 1957, that the statement made by a co-defendant against himself may be admitted into evidence supporting the crime of the determination of facts related to another co-defendant. Such holding has failed to treat a co-defendant as a witness in making a statement during a trial against another co-defendant, but instead it has admitted the co-defendant's statement into evidence against such other co-defendant merely because of his status as a co-defendant. In doing so, the holding has denied the co-defendant the standing as a witness in a trial for another co-defendant, and thus failed to follow the statutory investigative procedure as to witnesses. Hence, it is in breach of the Article 273 of the Code of Criminal Procedure as amended and promulgated on January 1st, 1935, and has unjustly deprived of such other co-defendant the right to examine the co-defendant who should have had standing as a witness. We therefore are of the opinion that such holding is inconsistent with the constitutional intent first described above. Those portions of the opinion as detailed given in the aforesaid two precedents, as well as in other precedents with the same holding, which are not in line with the intent described above, shall no longer be cited and applied. Under the constitutional principle of due process of law, the principle of judgment according to evidence, and the voluntary confession have been adopted as the determination of criminal facts in a criminal trial. Under the constitutional principle of due process of law, the principle of judgment according evidence and the voluntary evidence have been adopted as the determination of criminal facts in a criminal trial. Accordingly, the Code of Criminal Procedure has adopted the doctrine of strict proof, under which no defendant shall be pronounced guilty until a court of law has legally investigated admissible evidence and achieved firm belief that such evidence is sufficient to prove the defendant's guilt. And in order not to give undue weight to confession, thus negatively impacting the discovery of truth and the protection of human rights, the said code shall provide that the confession of an accused person shall not be used as the sole basis of conviction, and that other necessary evidence shall still be investigated to see if the confession is consistent with the facts. In light of the foregoing doctrine of strict proof and the restriction on the probative value of confession, such other necessary evidence must also be admissible evidence that should be legally investigated. Besides, as far as the probative value is concerned, the weight of confession is not necessarily stronger than that of such other necessary evidence, which should not be considered only secondary or supplemental to confession and hence flimsier. Instead, the confessions and other necessary evidence should be mutually probative of each other, leading to a firm belief after a thorough judgment that the confessed crime is confirmed by such other necessary evidence. Supreme Court Criminal Precedent 30 Shang 3038 of 1941, Supreme Court Criminal Precedent 70 Tai Shang 5638 of 1981, and the Supreme Court Criminal Precedent 74 Tai Fu 103 of 1985 were intended to elaborate on the meaning, the scope, the nature, and the degree of proof of such other necessary evidence, as well as its relationship with the confession. Furthermore, these precedents also stress that such evidence should corroborate the truth of confession, so that the confessed crime can be established beyond reasonable doubt. We therefore are of the opinion that these precedents, as well as other precedents with the same gist, do not run afoul of the constitutional intent first described above.